Welcome to A Dictionary of Finance and our special legal jargon episode. In fact, it's an entirely more competitive situation than usual on A Dictionary of Finance today.
This is Snooze, You Lose, the legal jargon game show, in which lawyers pit their wits against each other and we decide which of them we would pick to represent us.
We should also decide which crime we would possibly commit. That could influence your choice of lawyer too. But anyhow, today on Snooze, You Lose, the contestants are...
Kinga Scholtes. Kinga is a counsel in the European Investment Bank's Czech Republic, Slovakia and Eastern Neighbours division. She loves road trips. Her personal record is 10 countries in a single week.
Or as she says, hashtag only in Europe. Facing off against Kinga is Tom Gwynn.
Tom is a counsel in the UK and Ireland unit of the European Investment Bank's legal directorate. He got his first George Formby cassette at school from Ed Balls, who was later a British government minister.
Like George Formby, whose name will mean nothing to you unless you're British and over a certain age. Let's admit it, Tom, right? Tom plays the ukulele. Maria Serrato is a senior counsel for the EIB's Spain and Portugal legal division.
She's an identical twin, and when she's at home in Madrid, she's often mistaken for her sister.
Who is also a lawyer. Matthias Brzezinski is in the Austria and Germany legal unit of the EIB. Matthias is a surfer who once rode the dangerous waves of Siargao, a Philippine island surrounded by razor-sharp reefs.
Which shows that Matthias has nerves of steel.
But can he handle the pressure today, Alar, on A Dictionary of Finance's legal game show, Snooze, You Lose?
So let's go to the first round. And Kinga, what is Snooze, You Lose?
Well, this is exactly what it says. If the bank snoozes, it will lose the right to vote about a request from the borrower. So this is a borrower-friendly clause in financial agreements, and it provides the protection what I'm sure never happens in EIB, but eventually if maybe another bank takes too long time to respond to the request of the borrower, then the bank loses its right to vote on this request.
So this is a clause that typically the borrower wants to have included in all of our contracts, right?
Indeed. So that's why it's very, very, very rarely included in EIB contracts.
So it would be something that would be in a contract, but it wouldn't be, like if I'm a judge. Let's say, actually, I am a judge today. So let's say I'm a judge. I wouldn't say,
I see you like this role.
I do, yes. I'm not wearing the little wig today. But so if you're sitting there and you were a judge, you would say, I find the plaintiff guilty of you snooze, you lose. It's not that kind. It's not a verdict, but it's... What would you call that, actually, in legal terms?
Well, guilty comes into play in criminal law. Normally, banking lawyers are not the players on this field. It's more...
It's not a crime or a breach, as it were, Judge, but in reality, it's more of an omission. An omission, the failure to respond within a certain time, it's failure to act within a reasonable period of time.
But a breach, that's the word that I was looking for there. Because, we think of things, when we think of legal things, we think of crime.
Yeah.
But a breach is something that you might deal with more as lawyers.
Yeah, it's everyday commercial context, right? So a breach is when you don't honour or do what you're supposed to do, and the other side has a legal course of action against you. I think it's not as serious as a crime, but from a contractual, day-to-day, civil, commercial basis, it's quite important because... in real important, significant matters, issues, if the bank doesn't respond either because we don't know about it or we don't have the resource to get back in time, we could be put at a massive disadvantage. Is that right, King?
In fact, this clause is used in syndicated facility agreements where you have a high number of parties. Yes. So basically, everybody has a portion of vote in accordance with the exposure in the lending. So at the end of the given period, they calculate these votes together. Therefore, the vote of the lender who failed to respond in time will not be calculated. No. So, in fact, it's not a crime, it's not a breach, it's an option for the lender to express a view. And if it's not done in a certain amount of time, then tough luck.
Yeah. Yeah. Can I just, without meaning, sorry, it's the George Formby impersonator again. Mm-hmm. Can I try and put it on a more basic level, which is, you're hosting a lovely party, summer party, and you're inviting, it involves a lot of preparation, a lot of serious, work to make this party a big event. And then you send out your invites out, and typically you specify an RSVP, that they should respond and confirm their attendance at the party within a certain period. Otherwise, if you don't hear back, you assume they're not coming.
So there won't be drinks and food for you?
No, you just won't be at the table. I think at a basic level, conceptually, it's a bit like that.
Gotcha.
You're given a certain period, right?
So let's move on to the next question, the next puzzler. Maria, reservation of rights.
Well, I think the best way to put this through is with an example. Let's say I'm going to lend you, Matthew, 100 euros, and you have to pay me that money back in 1 year. So let's imagine the time comes, and after 1 year, you do not repay the 100 euros back to me. You default in your obligation. At that point in time, I could do two things. I could say, you are in default, you didn't pay me back, and I'm going to take proceedings against you.
What's proceedings?
Proceedings, I'm going to go to court, I'm going to say you didn't pay me back, I'm going to force security if I had anything, I'm going to do all the things I can do to get my money back. Or, because let's say you are my friend and I want to take a soft approach to you as my borrower, and I know you're going to get some extra money in a couple of weeks, I'm going to say, well, I'm going to give him a little bit more time. Let's don't do drama out of this. Let's give him a little bit more time. If I do that, it is highly recommended for me as a lender that I send you what we call in legal terms a reservation of rights letter. In this letter, I'm telling you, Matthew, you are in default. You haven't paid me. I'm not taking action right now against you, but I reserve my right to do so at any point in time. And why is this important? Because if I don't do that and I don't send you this letter, in certain jurisdictions, it could be interpreted that I'm waiving my right to be repaid.
You're snoozing and losing.
Somehow I'm snoozing my lose. And that's something I don't want to do as a lender. I want my money back.
Reservation of rights is a scary thing.
It's a way to protect yourself when you take a soft approach with your borrower.
All right. Well, let's keep on going. Tom, surprisingly, acting reasonably is a legal term. Is that right?
It's not what we usually associate with lawyers, of course, is it? But there we go. This is what we're going to find out right now.
You find no, fair point, chaps. But you think so, wouldn't you, that lawyers would insist on every party involved in a matter or transaction or case to act reasonably, because not just the law requires it, and common, the UK system is a common law system where it based a lot of previous precedents where people are required to behave reasonably in a certain conduct or matter or context. Except, of course, when the lawyers submit their bills, they may not be so acting reasonably. But anyhow, acting reasonably is a very complicated, despite the two simple words, it's a very complex history and application. So culturally, one part of the country, part of Europe, acting reasonably, unfortunately, means different things to different people, different standards. But in law, for example, typically, when we have clients who are required to do certain things, they think, well, it's going to be really difficult and not practical. So they will try and soften that, that covenant or requirement by insisting on having the words acting reasonably, in the circumstance. Because if it's not reasonable for them to provide us with a certain piece of paper or meet a certain deadline, then, it's only right they shouldn't be forced to do it and then accidentally cause a breach.
So acting reasonably, in the end, will be decided by a judge, what is and what is not.
The judge,
reasonable.
In most cases, will look back to a lot of cases in the history of acting reasonably and find, well, his question would typically be, what would a reasonable man or a reasonable bank or a reasonable party, borrower, do in that situation?
So it really goes back to, what is a tradition? What is a traditional way of acting in a certain situation?
Yeah, but it's much more stringent and full of clear guidelines, much more clearer guidelines than we think.
Clear guidelines
It's
based
not-
on precedents, right?
Absolutely, and based on the circumstance, yeah. Whether it's in a bank or in a shop or in a railway station, people are expected to behave reasonably within a certain situation.
Mm-hmm. So it's not just I know it when I see it.
No. It's not just a fluffy concept, you know. But maybe my colleagues at the table will share what they mean or understand to mean acting reasonably in their work and their jurisdiction. But in the English law system, it essentially means a reasonable bystander watching something. What would they do in that situation?
Well, we are a reasonable people, aren't we? That's true.
But on the continent, so people would rather try to avoid that kind of wording. They'd like to kind of specify what acting reasonably would mean in any situation.
Well, I think in European continental law, acting reasonably is something that is already embedded in the legal system. Nevertheless, we have a lot of clients that ask us to include the acting reasonably wording in certain undertakings because it just gives them more comfort. It just gives them the comfort that we are not going to ask something that is outrageous, that it's impossible to get. So many times we find ourselves adding acting reasonably in many of the clauses we include in the loan agreements. So that gives them some sort of comfort indeed.
It would not be a legal jargon episode if we didn't go to the Latin. Okay, so Matthias, pari passu.
Well, pari passu indeed is a Latin word. It means equal or on equal terms. In finance, we use it. Let's take a loan agreement as example. If a lender wants to be pari passu, it means that this lender wants to be on equal terms, at least on equal terms with other lenders. With other lenders, more specifically, in a situation where a loan is not secured. So it only applies in an unsecured situation. Typically, there are two ways to include this concept in finance contracts. You can either include it as a representation, which is a statement of fact at the time when you enter the contract, or it can be also a covenant, which is something which points to the future. So the lender wants to make sure that this status also will be preserved in the future.
Oh, so there's covenant and representation. Two more terms. He gets bonus points for that. Okay, let's stick with the Latin. Tom, in Britain, I gather there's a lot of Latin in the law, right? It's not just in general. So let's try ipsa loquitur.
If I remember, the last time I used Latin, this phrase actually means, in literal terms, the matter speaks for itself. Yeah.
So is that connected to acting reasonably?
Yeah, I mean, the matter speaks for itself and it follows that, in a sense. I mean, as a Latin scholar, I should really know what it literally means. But from memory, in a legal context, I think it follows that. So it follows from the action of a certain thing. So therefore, if a party or a man or a woman in a certain arrangement does something, it follows on the consequence of the breach, as it were.
So why wouldn't you just say therefore or thereby?
Well, in defense of Latin phrases in legal profession, there was a time when a combination, I guess, of snobbery and trying to judges very cleverly and intellectually summarize succinctly, briefly, a long, tedious case in a few phrases. And sometimes the beauty of Latin is it sums up these situations neatly in just a few words. That's not to forget that the origins of the UK and a lot of legal system derive from Roman law.
Indeed,
and therefore,
in university we study Roman law when we study law, at least 2 years in my case. So that was plenty of Latin expressions we had to memorize.
It's a hangover from the Roman law days, and also the need to summarize Latin complicated situations neatly, conceptually, using just a few very elegant Latin words. Obviously, it's 2017, and if a judge or a lawyer starts using Latin again, A, people switch off, and B, somehow it's seen as very snobbish, intellectual, highbrow sort of talk. So
I think Latin has its place and time because these are good definitions, and law contains a lot of definitions which make different sense in legal terms than in everyday terms. So acting reasonably, the Roman law equivalent would be, basically it's a standard of duty of care. In Roman law it was acting as a bonus ad diligent pater familias. It means that you had to measure any action against the action of a good and like morally good and prudent man who cares for an entire family and household. So not some crazy single guy running around and like acting like Casanova, or not somebody who is trying to get extreme amount of financial gain in a short term, but somebody who builds a future and takes care of people who are around them.
That would be great if we had just this model person who, to whom we give this title, that you're this model person against whom all the contracts are judged by, and then this title is passed on to the next. This perfect
I think
person.
we have 4 of them right here.
We do,
lawyers around
and I also think that perhaps after Brexit, and if we have to stop using British common law, we could go Roman law.
Go straight
sounds
back
like
to the Roman.
That sounds perfect.
Kinga, seeing as you spoke up for Latin, you get a chance for a Latin bonus point. Mutatis mutandis.
I actually love this expression because it very briefly expresses so many things. So instead of drafting 2-3 pages, I can just add a sentence. The changes apply mutatis mutandis in this contract. So it means new alteration or changing whatever is required to be changed. So, for instance, if in the original contract you had one single borrower and your amendment agreement introduces a new borrower, so now you have 2 borrowers, to be very prudent, you would need to basically rewrite the contract everywhere where it was singular. You would need to use plural, and it's enough to say that changes apply mutatis mutandis.
So if you would be working at a law firm where you charge by the hour versus the IB, you wouldn't use that because you'd actually want to rewrite the whole thing, right, to rack up the hours.
No, of course, I would act reasonably, and I would take into account the interest of my clients, so I would just add mutatis mutandis.
That's nice.
Maria, we can't let you get away with no Latin because you're the only person around the table who's from a Latin country, and you've done those 2 years of Roman law, so I think this is Latin, right? In rem security?
Indeed. I think the best way to explain this is if we go back to the previous example where I was lending you 100 euros, I may think, well, you're not strong enough to repay me that amount, so I'm going to ask you for some sort of credit protection. For credit protection, there's plenty of things I could ask you. I could ask you for what we call personal guarantee. Let's say, for instance, Tom or Kinga deciding to become your guarantor and paying back your loan in case you do default. Or I could ask for something else, what we call in rem security. In rem means against the thing. Actually, my protection lies in the value of a thing. So this could normally take the form of a pledge or a mortgage over an asset or a credit right. So for instance, if I think you're not strong enough to repay me that loan, I may say, you have to give me a pledge over your beautiful watch. So if you don't pay me back, I will take your watch and I'll sell it. And with that proceeds, hopefully enough, I will be able to get my 100 euros back. So I would be taking an in rem security over your watch, a security for the payment obligation that you owe me.
Well, I'm looking at my watch now, and we've come to the end of this podcast episode. You'll be able to tune in, of course, to another episode of the Legal Jargon podcast, Snooze, You Lose, in a couple of weeks. But right now, we should say thank you to everyone around the table for joining us. And we should decide on the winner. Actually, it's a game show. I think, actually, we have a tie between Kinga and Maria because the Latin was so good. I think that really won it.
You're the judge, Matt.
I am. That's right. But you are the jury. You have to decide.
I concur.
I just passed the sentence. Although I think we've decided we're not doing that kind of law today, aren't we? Because it gets too ugly. So this is the end of this episode of A Dictionary of Finance. Join us on Twitter. I'm at EIBMatt, M-A-T-T, to let us know what else you'd like to hear about on this podcast and let us know what you think of it. And you can also be in touch with Alar.
I'm at Alar Tankler, at ALLARTANKLER.
It's very unfortunate. We make you spell your name every week on this.
I'm getting better at it.
Yeah. It's really sticking, isn't it? So we'll see you again soon on A Dictionary of Finance.